My name is Jarrett Adams. I'm from the south side of Chicago. In 1998, when I was 17 years old, I was falsely accused and ultimately wrongfully convicted of a sexual assault that I did not commit. I spent almost 8 years in prison before I was exonerated with the help of the Wisconsin Innocence Project.
The case against Jarrett Adams, as presented to the jury, as the case was tried, was a really thin case. Really, most of the evidence, virtually all of the evidence of what happened both before and after the sexual encounter was entirely consistent with this consensual encounter, and really inconsistent with a non-consensual encounter. And it really looked very much like what I think is the reality here, which is that this young woman spent an evening of drinking and engaged in consensual sex that she later regretted, and as we have seen on other occasions, decided to turn it into a claim of sexual assault.
My family and I had absolutely no knowledge of the law. I had never been in trouble before and never really had any experience, or no one close to me had an experience with the law at this level. So we trusted my court-appointed attorney that the evidence against me was so weak and so thin that, he would come up with a strategy called a no-defense strategy. The thing with this theory that my lawyer chose was this no-defense strategy kept me from calling the one witness that would have proved my innocence. I guess my lawyer lost sight of the fact that this case had very little to do with the false accusation of a sexual assault. It had more to do with the issue of race.
In many ways, this case was sort of the classic racially tinged story of a young white woman who claims to have been sexually assaulted by oversexed black men. And it's one that is very, very difficult, when cast in those terms, very difficult for the jury in this white community in southern Wisconsin to look at this victim who's claiming these black men have attacked her and assaulted her. Very difficult for them to disregard her testimony or to say they don't believe her and to instead accept the defendant's claim of consent.
My trial lasted 2 days, and I have to say that it was like an out-of-body experience for me. I really didn't know what was going on. I didn't know any of the legal language that was being spoke. I was ultimately convicted, and once I was convicted, I went on to go to sentencing about a week later. When I was sentenced, the judge originally gave me 20 years, but I was given an additional 8 years because when I got up to speak, I addressed the court and I told them that I was innocent and did not commit the sexual assault. In prison, I survived only by the grace of God and my will to fight. I took it personal because I knew I did not commit this sexual assault, so I wanted to prove my innocence. It was so many things in prison that can get you sidetracked and get you in trouble, even get you killed. So what I did was I focused on my case. Every day I would go down to the law library and I would read books and I would try to understand what was going on in the courtroom that I didn't understand when I was 17 years old. At this time, I started to understand the law a little bit, so I started to write letters. I wrote letters every week to different organizations. Ultimately, one day, I wrote the Wisconsin Innocence Project, and they took my case.
So Jarrett's basic claim in this case was primarily one of ineffective assistance of counsel. And essentially what that means is it's a claim that his lawyer did not perform adequately up to the requirements imposed by the Sixth Amendment of the Constitution. That's the right to counsel provision in the Constitution. What was so important that was missing in this case, the defense counsel didn't present, was the testimony of a third party, a neutral witness who was friend to neither the defendant nor the complaining witness, and who had seen events prior to and immediately after the alleged sexual assault, and could in very powerful terms corroborate Jarrett Adams' claim of how things went down, and significantly undermine the credibility of the complaining witness's testimony. And I suppose the common understanding is probably that if your lawyer screws up, if your lawyer doesn't do a good job, you get a new trial. The reality is not quite that simple, and it's not quite that easy. And that's largely because the courts have established a fairly onerous standard that one has to meet in order to be granted a new trial based on a claim of ineffective assistance of counsel. As the courts like to say, the Sixth Amendment provides a right to an adequate defense attorney or an adequate trial, not a particularly good or perfect defense lawyer or trial. Because that standard is so high, so difficult to meet, the vast majority of claims of ineffective assistance of counsel are routinely denied. So this looked like a very high mountain that we were going to have to scale to obtain relief for Jarrett.
Legally, I knew that I had a very slim chance of getting my case in the court and getting it thrown out and getting my conviction overturned. But I couldn't think like that. In order for me to survive in prison, I had to live each day like I was going home the next.
And I have to tell you, I was always impressed with Jarrett, that here he was, this young man, hadn't gone to college, certainly had no legal training, and he understood the law. He understood it really well. He understood it better than a lot of lawyers out there, and in fact, he was advising us about this claim ought to be included. Look at these cases.
I was convinced that I would win my case, but I continued to get different results from the court. After appeal after appeal after appeal was denied, and finally, my case was heard in the Seventh Circuit, and that's where I won.
This case made a really significant statement, in part because we won relief in the United States Court of Appeals for the Seventh Circuit. That's the federal appellate court for the region that covers Wisconsin, Illinois, and Indiana. This is a court that's known as a tough court. It's a fairly conservative court. It's hard to win criminal cases in this court, and it was a real long shot to get any kind of relief from the Seventh Circuit. But not only did the court reverse Jarrett Adams' conviction, it did so unanimously. It concluded that, in fact, the state court decisions were not only wrong, but unreasonably wrong. And in the course of so doing, the court expressed in no uncertain terms its conclusion that the evidence against Jarrett Adams at trial had been very, very thin evidence indeed, and that therefore, this new witness who would have corroborated Jarrett's claims and undermined the complaining witness's allegations, it did indeed undermine their confidence in the outcome of the case and lead them to conclude very firmly that a different outcome was quite likely upon a retrial.
My wrongful conviction is just part of the story. The real story is what I'm doing now with my life. I was released in February of 2007. In May of 2007, I enrolled in South Suburban College. And in the spring of 2010, I'll be graduating with honors with my associates in liberal arts. I'm now applying to four-year universities, and I'm happy to say that I'm going to be the first male to walk across the stage in my family. After I obtain my bachelor's degree, my next step will be law school, so that way I can fulfill my dream of becoming a lawyer.
You know, every exoneration is unique. Everyone is powerful. This one is really special in its own way. Everything ranging from the fact that when we first took it, it was one that I had really very little hope that we would succeed on it. And then to see Jarrett get out of prison, ultimately the state dismissed all the charges, as was appropriate, the only thing they really could and should have done. And then to see him get out, go back to school, do really well in school, set his sights on going to a first-class university and ultimately becoming a lawyer. He will be a fine lawyer. He will be a really fine lawyer.
You know, people often ask me, are you upset? Are you mad? Are you angry? Yeah, I'm mad, I'm angry. Yes, but this is my fuel. This is the fuel that drives me to become a lawyer, to open up as many eyes as I can, and to be able to defend against the same thing that ultimately got me convicted. Not having a defense.